The presentation was partially prepared. If you look on that first slide, it was by Denise Montgomery, who was a candidate back in 2003. I've taken her and given her credit for the outline that she put into this, and then I have added to that. If you use this in the future, you can just add your name on the bottom of that. I have a disclaimer that is on the second slide. That my attorney said, just put something out there that says you're not practicing law here. You know, this is for the test, not for anything else, and that everybody ought to use an attorney when it really counts. And so, the setting that we have, and I would like you to change your slides if you would. There are 16 laws and regulations questions on the BOG exam. There's 16, which amounts to 8%. So it's kind of close, but it's still a small portion. And if you look in the Board of Governors exam reference manual in that test exam, you'll be hard-pressed to find questions in there that have to do with laws and regulations. But be ready, there are 16 questions. And as we get into this, there are 30 slides total in this presentation. That's a lot of slides, and there's a lot of detail if you pulled that up on your that I sent you on the email. We want to go very, very fast, but so please interrupt if you want to. We want to make sure there's good, lively discussion, but there is a lot of information, and the detail is going to be, when you study, you're going to find that this outline that was prepared is going to give you the essence of what you need. In my deliberations and all of that, not only the outline, but since the 3 books that were recommended on
managed
healthcare. Then there was an HR book, and then there was a finance book, right? And those were the 3 main ones. There's very little in the of law and regulations in those 3 books. If you go onto the website, you'll find that there's a law of healthcare administration, the law and public health, and the one that I used, I got it on Amazon for $60. It lists for $91. I got it on Amazon for $60. It was contemporary issues in healthcare law and ethics. As I review this with others, you may, if you feel like you want to have this in your library, the law and healthcare administration is easier to read. The law and public health is easier to read. Healthcare law and ethics gets you the detail if you have a penchant for detail and the laws and regulations. When you get into it, there's a couple of Latin phrases so that we can all act like we are attorneys and big shots. We've added this, and I'll give you this. This is a new slide that I added because there are 3 Latin phrases that go into this, and that is per se. We use it a lot. It means that in itself, that whatever they're talking about per se has no other strings attached. It's just all on its own. Qui tam has to do with whistleblowers primarily. The qui tam writ that they have is a writ whereby a private individual who assists in the prosecution can receive all or part of any penalty that was imposed. The reason qui tam in itself is just a shortening of qui tam pro domino rege quam pro sic ipso in hoc parte sequitur. That is and translates, who as well as the king as for himself sues in this manner. And that's the legal term, and I'll send you that, and I'll send you the update on this when I get back to my office. But and then one that we use a lot, quid pro quo, this for that, usually in a harassment case. You hear that a lot. If you will do something for me, I will give you this. But it also has to, it gets into those things where undue enrichment, and also when you're recruiting somebody, are you going to give them a salary in which they're going to give you admissions to the hospital, or there's going to be more value given. Quid pro quo is a good one. Those are three very good ones that in healthcare that you ought to look at. As three tests that as you get into healthcare law, you as an executive ought to be looking at three different things when you're conducting yourselves in healthcare. One is, are you as a healthcare executive acting in good faith? That is, are you honestly pursuing an end here? Are you doing it in good faith? That comes out in all manner of different legal entanglements that you're doing. But are you doing it honestly pursuing it? Are you as a healthcare executive acting with reasonable care? Are you? That's that old. Those of you who've had any kind of law class, this is reasonableness. Are you acting in a way that people could anticipate? Does it make sense? Does it pass the smell test? If it doesn't, you've got to get some help. And then, is that healthcare? You as a healthcare executive acting in the best interests of the corporation in mind. Now, some of you are with not-for-profits. Still, that's a corporation. They're the 501c3 not-for-profit corporation. But if you are acting in their best interest when you're running your organization, then you have their protections of their legal department and all the things that you're doing. And so, but if you're outside of that, then you're on your own, and usually you have to find your own attorney and your own defense and all of that. So in legal entanglements, if you just look at good faith, reasonableness, and in the best interest of your boss, you're going to, the owners of your organization, you're going to find yourself is going to be, you're going to avoid a lot of pitfalls. Let's start looking at the different categories that in one of my courses in graduate work, they said there's 27 federal and state agencies that regulate us in healthcare. It doesn't matter what organization we're in, whether you're a hospital or you're a clinic or a public health institution. You've got a couple of score. You've got at least a score of agencies that are looking at you, and these regulations can be rather onerous. So let's look at the actual laws that we are faced with. How are we running on time? Okay. Human Resource Law, FMLA, Federal Family Medical Leave Act. That has really deals with how you can you can be taken out of the workplace to help you in a birth, adoption, foster care, if you've got a health condition with a child, a parent, or with yourself as an employee, that you can get some relief and be able to protect your job while you're out taking care of that difficulty. The Fair Labor Standards Act, that started out some time ago with back in the actually in the 60s, the mid-60s, had it nexus at that time, where dealing with overtime, minimum wage, child labor protections, Equal Pay Act, and we've seen that refined over and over again with regulations and laws. And there's a wealth of good information on the internet if you're having any difficulty understanding that. EEOC, Equal Employment Opportunity Commission. Once again, that came through the Civil Rights Act of '64, and a lot of titles which protect us with Americans with disabilities, rehabilitation, and the age discrimination, all those things that we as professionals deal with on an ongoing basis right now. Human Resource continues on with ERISA, ERISA, Employee Retirement Income Security Act of 1974, dealing with some very, very terrible abuses of pension plans, especially by the Republicans, I might add. They really plundered him during that time, and they refined it even better during the Reagan administration. but they got those under control, and now now we have to just deal with our 401ks, and there's a whole lot of protections that are in there. Workers' compensation. Most states have better laws than the feds do, but it has to do with people who are disabled or killed as a matter of their work, monetary rewards, and that. Americans with Disabilities Act of 1990, the ADA, continues to evolve. In fact, in 2010, there are additional accessibility standards and having particularly to do with access to medical care for individuals with mobility disabilities. That is an area that you have to study in great depth. Each of your organizations should be reviewing that on when you get into as an employee or as a leader as part of your training, because even people with drug and alcohol abuse problems have protections under ADA, and so and there are people with that are constantly being taken advantage of or neglected under that, and so we could spend a whole hour just dealing with any one of these. Antitrust laws goes back clear to 1890 and has morphed over time in ways that the government can make sure that the free enterprise system continues to work. They look at two rules. They want to see if there's a conspiracy among people. There's a rule of reason analysis that in that last paragraph under that slide, they want to look at the reasonableness of the business practices, and then the courts balance out the merits of that proposed conduct versus any potential anti-competitive effects. And they really determine whether anything is antitrust or not. Usually when you have too much control of a marketplace, they're looking at fair market value, they're looking at price fixing and things like that all fall into that, and it crosses more than just healthcare laws. The Clayton Act is one which they looked at, where you take advantage of certain pricing advantages that hospitals have particularly. A good example of that would be in the pharmacy. Hospitals can buy morphine at prices that for cents on the pennies on the prescription, yet a retail pharmacist has to pay several dollars for that same equivalent pharmaceutical. The Clayton Act says, listen, if you're getting the advantage of that big discount because you're delivering hospital care, you can't compete unfairly with the retail pharmacist. So we have to, you've noticed that some hospitals will have a retail pharmacy. They have a separate license, separate rules, separate buying, everything like that. But it's so that they don't take advantage of the economy, people around, and so they can keep that retail pharmacy going. There's the antitrust, except for Pennsylvania and Vermont, each state that you work in will have their own rules that you need to be careful of. It won't be on the test, but some of the antitrust things, it'll only deal with the federal perspective of trying to make things fair in a fair market value. There are some safe harbors when we're looking at agreements that we might have with different groups to avoid the antitrust laws, and those are enumerated there. There are 6 items that you'll want to read after the presentation. Hill-Burton Act is one which isn't really talked about very much, but the implications of that, of having community service, back in fact, I've been at 3 Hill-Burton hospitals, and we still have to keep that community service obligation that remains indefinitely, because back in the through the early 60s, people were getting funds to build hospitals, and facilities of mental health hospitals, nursing homes, a number of different things that even though the obligation for many of these sunset after 20 years, we still have that obligation. When a not-for-profit sells out to a for-profit system, the Orphans Court will make that group form a foundation, and that foundation continues on well after that with the proceeds of that sale. They'll proceed on and continue to provide community service to the.
So who do you think polices that, just out of curiosity?
Oh, it's very, very rigorous. There has to be reporting. Anyone who feels like there's an infraction can turn that in to the state. I know in Pennsylvania, you have to change that. I'm from a for-profit, right, and we set up a foundation, and there is a separate board that watches over that. It's not it has no control whatsoever by the for-profit that is there. It really is a not-for-profit entity. So if there are abuses, you need to go to the foundation first of all and understand what that is, and then there's a they have to tell you how.
No, that is saying, well, you're not doing enough, or you should be kicking it up, or yeah, some level of community service. Because community service is expensive in today's world for organizations, and people cut back. And I see it in my own organization: cut back, cut back, cut back, cut back. So who, it's not like the big brother's coming in to say, well, yeah, show me what you did, and I think that's enough, or anything like that. That's not occurring, right?
Right. No, there's very little automatic scrutiny like you would with Centers for Medicare and Medicaid Services and that. Tax-exempt issues, 92% of all hospitals, and that's what I know more than anything else, are 92% are tax-exempt, 501(c) or some form of 501c3 foundation, not-for-profit corporation, and the lines are blurring between not-for-profit and for-profit, especially as much money as the not-for-profits generate and work with. There are 4 requirements there that you can see in a hospital setting. They must have a community board. They have an open staff where all qualified physicians can come in, a 24-hour emergency room, provision of charity care. That's being blurred because everyone, it doesn't matter whether you're for-profit or not-for-profit, you can almost parallel the charity care that each one is doing. The revenue ruling, 9815, sets out some more detail on tax-exempt issues. They look at joint ventures, that particularly, and they have a 2-pronged test. When you're having a joint venture with another hospital, when you're having joint ventures with physicians in medical office buildings or anything else, you've got that 9815 ruling that says, first of all, you have a purpose test, and there's does it jive with what your primary purpose of the hospital and the not-for-profit corporation? Are they parallel, or are you just avoiding taxation rules? The second prong in that would be the control test, is who is really driving it. Is it being driven by charitable purposes or public purposes, or is it being driven by economic and market forces? Okay. A big one that we could spend probably 2 evenings on is EMTALA. And it started back in 1986, intended for anti-dumping. There were 2 areas where the inner city hospitals were being dumped upon by some of the boutique, and it wasn't just for-profit hospitals going after dumping onto the not-for-profit. Everybody was guilty in this, and they said there's going to be some provisions here the Emergency Medical Treatment and Active Labor Act. And that act, since 1986, has been amended in 2000, 2003, 2008, and now there's another huge effort ahead, and we'll probably have one during 2011, so that it's consistent with the Obama initiatives in healthcare reform. But they want to make sure that there's an adequate medical screening, that you don't look into someone and find out if they have the ability to pay before they are in the emergency room. The hospital may not delay the screening until they can figure some things out. They have to treat them just like every other patient. The Medicare program drives so much of this. Without the Medicare program in southeast Pennsylvania, we would have a lot of bankrupt healthcare system without that there. So you have to do the EMTALA in order to be qualified with the feds for Medicare. They published the changes in 2003. Each one of these changes comes about in defining the initial rule, but nothing has really changed to the basic rules of EMTALA. For example, they've extended the coverage if people coming by car. They needed to define what about people who come by ambulance. They didn't think about that in the original law. They look at things on doctors doing the check. Well, what about midwives that come in under the active labor portion of that? And they said, okay, all of the caregivers, whether they're extenders or whether they're physicians, they're going to fall under this as well. And what is the definition of active labor? It's in the law, but what is it? There's false labor, there's active labor, and they help to define that in each one of these. Now, it will take a new tack, and that will be an effort in the 2011 is going to, looks like it's extending EMTALA to make sure that healthcare organizations take in people in an effort to make sure that Medicaid does not get abused. And so we'll see those things emerge this year. Another big issue that we'll deal with are START laws. START regulations prohibit physicians from referring Medicare and Medicaid patients to an entity where the physician or immediate family member has financial interest. That's what Stark, I think he's a representative in Congress. Yeah, and he was very, and then they've come up with Stark 2 and a number of things that have worked off of this, trying to make sure that there are no opportunities for people to give incentives that rock the free market, that unduly enhance the financial viability of someone's life of self-referral. They've given some exceptions to that. Most hospitals, clinics, public health, they recruit physicians, and they cannot have any strings attached to that recruitment. If you recruit them and give them a very, very high compensation, they've ruled against that. They say you need to look at fair market value for these. And nothing can be hinged on the quid pro quo as we'll give you more money if you admit to our hospital. We'll give you more money if you'll send more patients to our clinic. We'll give you more money if you don't send these kinds of patients to our, there's a negative aspect, quid pro quo. And so there cannot be any restraint in credentialing and a number of things that would be entangled into giving undue compensation. Stark laws were modified just a couple of years ago again, where if a physician was recruited into a group, say there were 2 physicians and they wanted to go to 3 physicians, and they're already covering their overhead, Stark now will not let you deduct and spread that doctor's salary or his overhead over in his compensation. It has to be strictly his salary. And so there's some limitations, and you say, well, my heavens, how do you all the rules just keep getting more and more entangled, and this is an area where as you're doing recruiting and working with physicians, not extenders, but physicians, you need to seek regular counsel. But the essence of the things that would be put on the exam are within those Stark Law, that Stark Law discussion. Let's jump to the False Claims Act, which is the whistleblower that during 1986 that False Claims Act was enacted in a modern version, and this is where that Quitom whistleblower suit discussion earlier comes into play, where if someone who blows a whistle on falsely submitting claims and double billing and things like that, or billing for services not rendered, if the Justice Department gets involved in the process, they want something to cover their costs. So the whistleblower could get as 15 to 25% of the government's recovery. If the Justice Department stays away, there's a settlement out of court, those types of things. If they then the whistleblower would be entitled to 25 to 30% of that recovery, and it could make some people, some very wealthy people, very quickly, and have done that. People have received millions of dollars in some very onerous schemes, and I don't want to say the names of those organizations that have been caught in Quitom, but they because they've survived, and I don't really want to, it doesn't do any good on the test anyway. Okay, so the kickbacks and all of that will fall into that, into the false claims. HIPAA, I don't think there's anybody in this room or on the phone that doesn't know something about HIPAA and the regulations that you have to do. It started out with 2 paragraphs in the Health Insurance Portability and Accountability Act of 1996. My former state of Utah, Orrin Hatch was the co-sponsor of that, and there were 2 paragraphs in there that said that healthcare information will be easily available, and it will be strongly and fiercely protected. That has cost us billions of dollars as an industry and has spilled over into banking, as we know. And so it provides you access, and some key words in the BOG exam are going to be talking about what is privacy, what is protected health information, PHI. You need to know that those protected health information has some elements there that you want to review, and special uses are of information, which we can do if it's required by law, public health initiatives, victims of abuse, neglect, or domestic violence, judicial administrative proceedings, law enforcement purposes, organ or eye tissue donation, research purposes, aversion of serious threat to health and safety, workers' compensation, and there's also the issues of to do research and to do quality reviews and to do the normal business of your organization, as long as things are protected and privacy is administered to. Now, there's a real easy rule that I tell all of my employees, and I say, do you have a need to know, or do you have a want to know? And that separates it all down. Do you really need to know that information? And here I am, I'm the CEO, and I want to know something. I don't have a need to know most things that go on in the healthcare arena. But there are occasions that I do get that because I have a definite need. And so we give the minimum necessary. We We give individuals their rights. We let them know about those, and you can see what those individual rights are. And then also it swings over into business associates, the information that they might have, and the access that they might have to that personal health information, and the restrictions that are there. If you aren't familiar in your organization of HIPAA, all you have to do is you should have a HIPAA officer someplace in the organization, and you can get a good background on all of that. HQIA quality is always a big thing, and you once again back to 1986, which was a kind of a benchmark year of a lot of rules and regulations, and basically they HQIA helped us with the peer review process. Prior to that, the peer review was very, very suspect. It protected a whole lot of things, and they've refined over and over many things in peer review, and it has to be peer. You can't have nurses reviewing doctors and doctors reviewing extenders and things, and expect it all it really has to do with doctors to doctors and their review for the sake of improving, because we all know that there's a certain element in healthcare that is a science and a certain amount that is art. And it's when you get into the art of healthcare that it gets very vague and lots of grays. The science of healthcare is getting more black and white all the time. There's immunities that you need to be careful of, that you have to, that it will advance the quality of health care that you're doing in those peer review. I might mention that there's a great move across the country right now, and you'll hear this in the future, and that's proximate cause, meaning that if you that a physician does something wrong in your organization and is found guilty, the organization that credentialed them have proximate cause. It's kind of, it says that if you hadn't privileged him, if you hadn't been negligent in giving that the person the right to do that surgery or whatever, then you're culpable in this too. And so proximate cause pushes it back to the actual healthcare organization, which typically hospitals have said, was the nursing care right or was the doctor's care right, medical care? And they split on that. And so nursing care failure is the hospitals, and the physician care failure is the physician, and it's getting blurred. Credentialing is a big part of HQIA, and you have to have certain elements of things when you're credentialing. You have to have a license, controlled substance licenses, professional liability, references, background checks, photo ID, eligible or working towards board certification. Medicare does not allow you to have that as a requirement for privileging on the hospital, but the insurance companies can ask that. They can require that. So if we need to have board certified people, we kind of get around it that way. And they did not have board eligibility. They don't have that anymore. They have, you're either working on it or you are boarded. Here's an interesting one, Sarbanes-Oxley. You probably won't have any questions on the BOG for that, but it's something that every one of us should be aware of. That it was, you remember the great abuses of reporting profits and losses to corporations with the energy companies and those things. Enron, you know, that was going on, and then out of that, Senators Sarbanes and Oxley came up with their act in 2002 and said, this way you're going to have to report this, corporations. Well, it's now blurring, and that they're seeing a Sarbanes creep. If you're in a hospital, get the Trustee magazine that is out right now, and that's what this came from. Is that there's a Sarbanes creep into not-for-profits where the Internal Revenue Service is challenging not-for-profit status. How are the bond issuers and the insurers, how are they conducting their business? Do they fulfill the Sarbanes intent? And there's an increased board requirements to you as a not-for-profit person on quality, finance, billing, coding, and safety, and that expands onto that. Good article. And boards are requiring requiring of their administrators a higher bar. New Jersey is requiring 1 day of trustee training, which is part of the Sarbanes, and California is looking at their not-for-profit integrity, which has those standards for charities. Federal regulation process is interesting and very, very confusing. I just put that in there for you to know how rules are promulgated, and on all of these regulations, they have all come out in the Federal Register, and it's hard to read. It's small print. There's no pictures. You know, it is very, very difficult. But you'll see regulations in every one of these will be printed in the Federal Register after they're promulgated. Certificate of need is something that many states that we work in saying that you have to prove to us that that's really a justified need. Unfortunately, the certificate need was set up to try to cut redundant costs, but it really is a market controlling issue, and a certificate of needs are being written off in great detail. There may be a question on certificate of need because of the political ramifications for them. The theory's good, but the idea would be how many of you have an MRI in your hospital, and that was supposed to fall under certificate of need, and we've got to, we have too many MRIs in the United States, but we all have to have one. Joint Commission. Each of us, every organization, every healthcare organization has a requirement has an ability to be under the Joint Commission on the Accreditation of Healthcare Organizations. It used to be just on hospitals, and they don't like the moniker JCAHO, they don't like JCHO, and so they like the Joint Commission. That's what they want to be called, and so that's the new and improved version of it. And I apologize for not updating my my slides from the previous presentation.
I haven't been in this business since, in the JCAHO related business since 1985. I'm now going to write a book on the transitions that they've gone through. Money that has been spent just on their changing of a letterhead alone. Waste. Waste.
As you go into the BOG, you need to just recognize that the Joint Commission is a big part of that. Smaller community-based hospitals, usually they can go with they can get deemed status under a state, under some kind of state organization through the State Department of Health with their surveys. But with Joint Commission, you need to know that they are the ones that are accrediting. The joint comes because it's a joint between the industry and the United States Senate, and they meet together and try to determine how do we improve health care. One of those improvements is the 7 national patient safety goals to improve the accuracy of patient identification. You see those all: improve the effectiveness of communication among caregivers, improve the safety of high alert medications, eliminate wrong site, wrong patient, wrong procedure surgery, improve the safety of infusion pumps, clinical alarms, and the risk of health care associated infections. Many of those came out of different studies in the private sector, like the Leapfrog group that was all industry, and they came up with all industry-based, and they said, what are the things that are common with good care and what are common with bad care? And they found these things and persuaded the Joint Commission to infuse those into their regulations, and so we do that. I can tell you that from 31 years in healthcare, I've seen that this has made a difference in the delivery of care. If nothing else, making people aware that there are standards and making them think before they do many of the things that they do in the operating room, on the floor, and every other place. Patient Bill of Rights, very, very detailed. You probably, everyone in healthcare has the Patient Bill of Rights either in their front lobby in Spanish as well as English. It's very clear what those rules are. If you want to change them, they have to be either more stringent or no change from the Federal Bill of Rights, and you can see that there is a long detail there, and this is straight from the regulation. You're welcome to take your time to read that. But in conclusion, there was, I don't know if you know Lou Holtz, but he's a favorite coach of mine, and I was able to listen to him one time, and he came up with 3 things that we need to do, and I think that it'll help you in the Patient Bill of Rights. First of all, he said, do what is right. The next thing was do the best you can and treat others as you want them to treat you. And so much of the Patient Bill of Rights is treating people the way they would, and doing what's right and doing the best we can with that patient that is so important to the viability and success of our organizations. That's it. Now, what time do we have now? 5 up.
7 hours.
5 up. We have enough. 30 seconds a question, and we probably won't go through the. We may run a little bit over, but there's 10 questions that we talked about, and those are: first, in general, courts exhibit what attitude regarding controversies over medical staff privileges? What attitude do they have regarding those? Human lives are at stake, and the courts must intervene to protect the physician's rights to save those lives. If the decision were reported by reasonable evidence, courts will not substitute their judgment for the hospital board. Hospitals must not be permitted to interface with the doctor-patient relationship, and courts may not entertain suits regarding medical staff privileges. Anybody have an answer on that? It's B. The answer is, what do you have? Anybody anything different than B? It's B. Okay. Yeah, that they, supported by reasonable efforts, they will not substitute that hospital board. They will not interfere with what they say on medical staff privileges. That is the, and they get their rule through the state laws. That's very, very clearly mandated, and with CMS rules.
And that they're separate?
That
the courts versus
the ultimate appointing authority is the hospital board.
Okay. And you have a reasonable evidence.
Yeah.
Okay. Ballpark.
Reasonable evidence. Yeah. That reasonable word again.
Yeah.
Under federal law, whenever a patient comes to a hospital emergency department with an emergency condition, we have an answer on that.
B. Stabilize.
B. With few exceptions, the patient's condition must be stabilized before he or she is transferred or discharged. The big thing there is, and that's in your slide presentation, stabilized. They must be stable in order to. They are your responsibility until they are stable, unless you can make something fair out of it. Okay. 3. In considering the application for medical staff privileges, hospitals receive reports from a U.S. government clearinghouse on medical malpractice payments and adverse medical staff licensure actions. In general, these reports have had what effect? Everybody know that's the National Practitioners Data Bank.
I think it's C.
What's that?
I think it's C.
C, they have not received the reports. Most hospital privileging decisions would have been different.
Yes.
Anybody disagree with that?
That's what's B.
B? Reports have been timely and helpful and have reduced the complexity of the privilege process. Anything? The answer is A. Reports have rarely led to hospitals to make privileged decisions they would not made otherwise.
I disagree. I so disagree. I'm just so involved in all that stuff in my hospital. It does, and we do, and we won't move forward without. You know, they definitely won't move forward if they don't have malpractice information, and if they see malpractice information that's concerning to them, they stop in their tracks, and this is the medical executive committee, and then the board, and the subcommittee of the board that does credentialing at my hospital. I mean, just in my own experience, yeah. I have absolutely, and we've had those cases where I've seen them make decisions based on that information, as well as licensing actions, where they've required, I guess, further clarification that took over 12 to 18 months to finally clear up before you made a decision. But before you made a decision, it didn't change the decision, but it certainly held up a decision. And until we do it, we live it every day.
Well, I think the
I guess I would have left that one. I would have missed that one on the BOG, and that was.
Yeah. There it is. You're over.
Yeah. But you know, we do it, and that's why it's there. And am I the only hospital that cares about that?
No, I have too. But I think that where the trip is.
I don't know if it's timely. It certainly doesn't reduce the complexity. You know, and I don't know that practitioners are coughing up the information readily as they apply and reapply. So these data banks are hugely informative that way. I can tell you, I think that might be the case.
Yeah. As I looked at that,
what do you think?
And I tried to figure out why they said A. And I think that it is, if you're requiring all of those things, you know, you have licensure, you have their medical malpractice and things like that. Rarely, when you have all of those things in the credentialing lineup, rarely does the National Practitioners Data Bank change your decision. You see it in so many other ways as well. It does support that, but they're saying that rarely that led the hospitals make a different decision. When you're doing you look at that list that they said in the HQIA, it says, you know, that you're going to go through recommendations, and that doesn't mean just their 3 lists of people that they have for you, you know, their favorite buddies.
Right.
You have to look at the administrator needs to call the administrator of that. Yep. The chief of staff needs to call that chief of staff, and you smell it out. And rarely does the National Practitioners Data Bank change your decision. You've already found that out.
That's not my experience. Yeah, but I guess that's where they're going, so I have to adjust. Yeah. But clearly in my organization, we don't get, because I hear the doctors complaining, the credentialing team complaining that they don't get that kind of information like they want. People don't fill out the information the way they should. It's not clear enough. But boy, when they start to get information, and it's usually not a problem. I mean, 9 out of 10 physicians don't have malpractice issues, and they don't have red flags there. This is just red flag information. This is not, you're right, maybe that's the key here. This is not the decision maker, but these are data elements that could raise red flags that would change a decision. That then would go on for further discussion. Well, we have a practitioner applying for privileges, but, you know, and he's a surgeon. But look at his history of malpractice. Do we have a problem here with his performance and his competency? So now we got to go look somewhere else. Or I think I've seen it also in licensing actions where you've had physicians who've come into your state applying for privileges in your organization. They have had licensure in other states historically. We pull that data, and now we find, oh, well, 10 years ago, this person, you know, practiced in the state of, pick one, South Carolina, and gee, that licensure state had a blip on the screen, an event. Oh, God, now we got to stop everything, and you got to look at that and see what that means and what does that mean, and that's the kind of stuff that hugely delays people going for. But those are, to me, they're red flags. They don't, they are not the decider.
Right.
You know, they don't say just because they have data about malpractice, then we shouldn't credential. But they do have cause for further discussion. Maybe that's what the thing is. It's not the decider, though. Maybe
there isn't a medical staff. There isn't a medical staff, a hospital, a clinic out there. There isn't a, I can say from a hospital point of view, there is not a hospital that doesn't have someone on their staff that hasn't had a lawsuit or something that comes up on the National Practitioner Database. And when you have those claims showing up, but if you have a lot of them, there were other things too.
Right, or you have to look at them. And I think that's the credentialing committee's responsibility is to look for trends, look at, you know, what is this? Is there anything going on here? You're right. Particularly in our lovely state of Pennsylvania and more specifically in the Delaware Valley here where litigious happy and the lawsuits are rampant and the results are crushing the physicians here as we know it. So you're right, they're going to have a lot of data versus physicians from another state, I bet too. But
and even when they've had trouble, we put them on check. If somebody's really desperate, many times they just ignore that and say, let's get that guy on.
Really conservative where we are.
A lot of the human
conservative group of docs, and it's conservative. That's probably what I'm experiencing.
Let's take one more question, and I'm going to give you all the answers, if that's okay.
Sorry.
Which of the following statements best summarizes the prevailing legal standard used to judge the action of members of a not-for-profit healthcare organization's governing board? They must act in good faith with reasonable care in the best interests of the corporate in mind. They must exercise the same high level of fiduciary duty as applied by the trustee of a trust. They must avoid gross negligence and willful misconduct. They are immune from personal liability. I hope we all get this one.
Because it says best summarizes. I thought it was A.
That's
A.
A.
You've
only mentioned it 5 times in today's presentation. Thank you.
Okay, that really is. That's what we need to really look at. And that applies not just for a not-for-profit governing board, but all of us in good faith, reasonableness, and in the best interest of the corporate mind. 5 answer is A, 6 is C, 7 B, 8 C, 9 C, 10 A.
Can you do that one more time, please? I apologize.
Okay, I'm going to do all 10 of them.
Okay.
1B, 2B, 3A, 4A, 5A, 6A, or excuse me, 6C, 7B, 8C, 9C, and 10A. There are no D as in dogs. There's no Ds.
I know we're running over, but could you briefly explain 7?
Okay. Let's go to 7. A non-legitimate reason, now that's got the base legis, which is law, a non-legal reason to release information from a patient's medical reason is 1, subpoenaed by court order, requested by the spouse or next of kin, the spouse becomes incompetent, or reporting the statistics for a research project. Now, the subpoena by court, we understand that one. They can require any of that information. C, the patient becomes incompetent. The court will order that information, deem them incompetent, and can get that information. There has to be in healthcare, if someone is incompetent, you have to go through the legal process of either getting a family member or even the hospital becomes their legal guardian and makes those decisions for them and can release the information to get them transferred or whatever. D, the reporting statistic for a research project are the research will not disclose the name They need to identify them, and they may be working with their names in the beginning, but the results all come out in the aggregate and doesn't divulge anything. But you have to start someplace with that. So B, even because the next of kin or the spouse want to know, they don't have a need to know. And believe me, if you've been in healthcare and you have a disenfranchised spouse or a next of kin that's nosy, I've fired a next of kin for accessing our information and getting information on her aunt. And it settles it right down. Nobody likes to get fired for that stuff. That's why they have a curiosity. They have standing in
the research. There has to be an understanding. There's more clarification would be nice, because in the research project, the patient has to be enrolled in the research project.
That's right.
Yeah, that's what can't just like here at Penn, we just can't go out and tap everybody's medical record because, hey, all those people would fit into our research nicely, so they don't know, but we're getting their data, so they have to be, that was not clear. So that was throwing me off, too, because I'm thinking you need to have and then just because you're confident doesn't mean the information should flow, you know. But as you described, it just isn't enough information, so the question was a toughie. Cool.
What you'd have to ask yourself is, under those conditions, can they get a hold of that information? Just on the matter of the reason that they're the spouse or the next of kin is not a reason.
Right. But if you're incompetent, you have to have somebody else controlling that, because if you're incompetent, you can't protect yourself. So that doesn't give license for the whole world to say, he doesn't know what we're grabbing.
Yeah, I had a problem with that one just for that part. You know, just because they're incompetent, there has to be somebody that is assigned, power of attorney or something.
Right, right. It just can't be, well, here, he's incompetent, so guess what? We can run rampant on that record.
Yeah, it's a little light in regard to the answer.
I know. So, tough question. That was a great review. Yeah,
Very
thank
good
you.
review.
Thank you. It was fun. It was. I think any of you.
I'm glad you did it, because I don't think I could have done it.
Anybody who's done this before, when they get done presenting,